Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today, guys, I'm gonna be giving you guys a summary of the Ripple v SEC lawsuit, and more specifically, what Ripple's defenses really are. This is not necessarily any new information, but it's summaries for all the people that have joined right now and don't exactly know what the lawsuit is about, or people that have been going on for a longer while here but have kind of forgotten, because this stuff isn't mentioned too often anymore. But as we head over into the newest phase, summary judgment pretty soon here, this is going to become a lot more important. So big shout out to Status for making this. Over 100 pages summarized. It is very freaking interesting. So, SEC update, answer of defendant Ripple Labs to plaintiff's first amended complaint, March 2021. Affirmative defenses. Ripple alleges, asserts, and states the following defenses as separate and distinct defenses to the complaint. By virtue of alleging these further defenses, Ripple does not assume any burden of proof, persuasion, or production not otherwise legally assigned to it. Alright, so first defense, failure to state a claim. The complaint fails to state a claim upon which relief may be granted. I think that one is quite obvious. Number 2, XRP is not a security. Now this one is a little bit more, I guess I'm going to say all of them are debatable. Not all of them have been tried to strike down, but SEC not exactly saying what the problem is, them alleging something was just not true. Ripple did not violate Section 5 of the Securities Act because XRP is not a security or investment contract, and Ripple's distributions or sales of XRP are not investment contracts. Number 3, no likelihood of future violations. The relief requested in the complaint is inappropriate, in whole or in part, because the complaint fails to allege a reasonable likelihood of future violations by Ripple. Well, in this regard, we can actually say the lawsuit here hasn't got a lot of purpose. I mean, if Ripple has done stuff in the past, but will never do so anymore in the future, and I guess it's also because we're kind of biased. Like, I've been reading so many updates that I know by now that for the SEC it's going to be extremely difficult to basically allege things before 2018. And so if it's only between 2018 and 2020, and not in the future and also not before that, but even that time, those 2 years are going to be extremely difficult because there wasn't proper clarity, then doesn't have a lot of purpose, because this lawsuit, the damages basically are going to be diminished from 1.4 billion to maybe only 100 million as an example, maybe 400 million, who knows. However, it's going to be an interesting one to kind of look at that. Now, defense number 4, lack of due process and fair notice. And this specific one, guys, the SEC tried to strike down and is still trying to strike down. Ripple did not have, and plaintiff failed to provide fair notice that its conduct was in violation of the law. In contravention of Ripple's due process rights, due process requires that laws give a person of ordinary intelligence a reasonable opportunity to know what is prohibited. And obviously, I'm on Ripple's side with this one. If the SEC didn't make it clear that what they're doing is not allowed, then how could they have known? And even if they thought they were doing something wrong, if the law does not support that, I think that Ripple's in their best right. And now, guys, before I move on, make sure you check out 5 Minute Crypto, which is my second channel. You might want to check it out because, well, I post a lot of cool updates on there. Not too often. I do every couple of days or so, but it's definitely worth it to go subscribe to it. So I'll leave a link down below, guys, and also make sure you press the like button down below here to help out. And if you have any questions, pop them down below. Maybe some people will come in and answer. And if I don't forget, I'll also try to answer your questions. Number 5, exemption from registration. Even were the court to find that XRP constitutes a security or investment contract within Section 5 of the Securities Act, plaintiff's claim against Ripple is barred in whole or in part because Ripple's distribution or sales of XRP were exempt from the registration requirements of the Securities Act and or the regulations promulgated thereunder. Number 6, lack of extraterritorial authority. Plaintiffs lack extraterritorial authority over all or some of the transactions alleged in the complaint that took place outside the United States and or were made on foreign exchanges. And number 7, statute of limitations. Plaintiff's claim and plaintiff's request for civil monetary penalties are barred in whole or in part by an applicable status of limitations, or statute of limitations. This last one, as of this point, I still don't know exactly what that would mean, but I guess that's just some legal jargon, right? However, ultimately, it's not going to make that much of a difference because we understand the rest. All right, so let's read what else we got here. Here's SEC for Ripple, quote, this is from an answer of defendant Ripple Labs, Inc. to the plaintiff's first amended complaint. Quote, treating XRP as a security, by contrast, would subject thousands of exchanges, market makers, and other actors in the gigantic virtual currency market to lengthy, complex, and costly regulatory requirements never intended to govern virtual currencies, end quote. That's a reference to the fact that right now all rules are based upon normal securities, basically, not these digital virtual currency things that we are messing around with now. Then, this is an answer of defendant Ripple Labs Inc. to the plaintiff's first amended complaint. The SEC filed this complaint 8 years after XRP was created, 5 years after the Department of Justice and FinCEN characterized XRP as a virtual currency, and after more than 2.5 years of investigation, during which the SEC allowed defendants to continue to distribute XRP, allowed the XRP open market to grow, and allowed millions of market participants to rely on the free and efficient functioning of that market. Which obviously is strange, whatever way you want to pull this from. It is really odd they allowed that. And this is actually one of the points which we come back to most often, I think. The fact that they should have done more against Ripple earlier. And a critical part here is that we got some guidance 5 years ago, or at least we thought, and now I think it's up to the SEC too to show that the guidance that they gave is not sufficient. But then again, even 2.5 years, we got some guidance from Hinman, and the Ripple got investigated, right? But how can they investigate something for 2.5 years, then still after that have their facts half-assed, can still Ripple not exactly know what they are alleging, and they can still change their allegations left, right. It's just a strange lawsuit, guys. It really just is. And then we got, and by the way, I think some of these actually have more in them, right? Because I think here we also have 3 of them, actually. We also have XRP functions as a medium of exchange, a virtual currency used today in international and domestic transactions. Moving value between jurisdictions and facilitating transactions is not a security, and the SEC has no authority to regulate it as one. And then in 2015, and again in 2020, the U.S. Department of Justice and the U.S. Department of Treasury's Financial Crimes Enforcement Network determined that XRP is lawfully used and traded in the marketplace as a virtual currency. Now, a rebuttal to this one is that FinCEN, the IRS, and the SEC can all see a thing, basically, as something else. For example, FinCEN can see it as a currency, the SEC can see something as a security, and the IRS can value something as a commodity. And that's basically because the U.S. has some strange systems in there where every specific legal body there can see things in a different manner and basically regulate it in a different manner. Determined that XRP is lawfully used and traded in the marketplace as a virtual currency. Securities regulators in the United Kingdom, Japan, and Singapore have likewise concluded that XRP is a virtual currency, not subject to security regulation. All right, moving on though to this one. Upon information and belief, the SEC had meetings with multiple other companies that traded or facilitated activity in XRP or planned to do so, and in such meetings, including as recent as 2019, the SEC did not tell those companies that XRP was a security or that transactions in XRP would be subject to federal security laws. And the same thing here goes for somewhere at the end of 2020, when one person sending a letter to the SEC didn't get the reply that he could not trade it. He got a reply saying it's a 50-50 kind of. Now, the complaint's mere filing has caused immense harm to XRP holders, cutting the value of their holdings substantially and causing numerous exchanges, market makers, and others, market participants, to cease activities in XRP. In bringing a case that alleges an unregistered offering of just over $1.3 billion, the SEC has already caused more than an estimated $15 billion in damages to those it purports to protect. Now, Ripple did not sell or distribute XRP as an investment contract. Ripple has never offered or sold XRP as an investment. XRP holders do not acquire any claim to the asset of Ripple hold any ownership interest in Ripple, or have any entitlement to the share of Ripple's future profits. Ripple never held an ICO, which Ethereum did. Never offered or contracted to sell future tokens as a way to raise money to build an ecosystem. Never explicitly or implicitly promised profits to any XP holder, and has no relationship at all with the vast majority of XP holders today, nearly all of whom purchased XP from third parties on the open market. And the last three, Ripple has no explicit or implicit obligation to any counterparty to expend efforts on their behalf. Proceeds of XP sales are not pooled in a common enterprise, and holders of XP cannot objectively rely on Ripple's efforts. And Ripple could cease to function tomorrow, but XP would continue to survive and trade in its fully developed ecosystem. Ripple holds a large percentage of XRP, but that alone does not and cannot render it an investment contract. Many entities own large amounts of commodities. Exxon holds large quantities of oil. De Beers owns large quantities of diamonds. Bitmain and other Chinese miners own a large percentage of outstanding Bitcoin. But there is no credible argument that substantial holdings convert those commodities or currencies into securities, nor has any case so held. Then it is especially important that the court rapidly determine, that's kind of funny, the most consequential and overarching issue, whether Ripple's current distributions of XRP are investment contracts under the existing US security laws. The answer is a resounding no, and reaching that determination quickly is urgently needed to provide clarity to the market. And I kind of guess, right, that's actually one basis that I'm not too sure about even right now. Is Ripple still in violation or not? I know that when the SEC tried to allege that it was kind of, numbed down rather quickly, but I still sometimes wonder if that is being alleged right now as we speak. That, once more, they are still selling these securities or not. Because if not, what changed? And why is it not the case then? Because Ripple's operations are still the same. So what exactly changed in that sense? But yeah, it's rather interesting, all these important quotes. It's kind of visual summaries of the Ripple's answer all the way back then. But in a sense, I would say it's actually a, how do you say it? It's a summary of most of Ripple's thoughts in this entire process, right? And once more, guys, I'm not sure if there's actually an updated version of this all somewhere out there as well. I don't think it really matters, though, guys, because if you think about it, this is already enough to just kind of see in a visual manner here, but mostly just hear exactly what Ripple's side is, exactly what the SEC side is, where the SEC is alleging all these things, basically. I think it's rather juicy. Just to get a little small refresher for all the people that are, kind of out of the loop or anything along those lines. So, yeah, I don't want to take you for too long here. Hopefully you enjoyed it. Hopefully you learned something new, or hopefully you refreshed your memory a little bit. A little bit later, we got a lot of updates coming out, so make sure you subscribe to the channel. And once more, guys, 5 Minute Crypto is going to be a ton of videos on there too. So make sure you subscribe right now, and I'll see you guys again in another crypto video later today.